And hello, it's Dennis Block on another podcast, and I've got a special guest here today. I've got David Crown from Los Angeles Property Management Group. He's really one of the premier management groups in Los Angeles County. And how are you today, Dave?
Doing great, Dennis. Thanks for inviting me down.
Hey, so I've had the experience of actually working with your company, both as a landlord who's managing my properties and also as an attorney representing your clients. So tell me, how is property management in LA County?
In a word, complicated. But we do the best we can to cut through a lot of the issues that are being raised daily. And it's all about the team, really, more than anything else. You have to work with people that you trust and that show up and really put on their best game. That's critical.
And what kind of, what constitutes your clientele? Do you have like small units, big units?
I have a couple owners that have several hundred units. Actually, my largest client is in Sherman Oaks with about 300 units. I should say we recently took on a client in Hollywood that has 380. So, but that's sure not my typical client. We deal with a lot of mom and pops that have duplexes to 6 units and single family owners as well. So we're grateful for all of it. Really.
And that's Los Angeles Property Management Group.com, is that correct?
That's it, or lapmg.com if you're in a rush.
Well, today's September 22nd. We're getting close to Election Day, which is going to be November 6th. And I have been pounding the trails with different seminars advising everybody to please go out and vote no on Proposition 10, the deceptively called Affordable Housing Act, where they're really going to try to take away our property rights. So please go there and vote and bring your friends with us. It's not only going to affect landlords, but it's also going to affect single-family property owners where you have a single-family home which was exempt at least up until this point, and now, believe it or not, you're going to have potentially rent control for single-family homes. So everybody out there, remember to go and vote. First topic I want to talk about is, Dave, I came up with a new notice, and tell me your experiences. When you serve a 3-day notice to pay rent or quit, and the tenant contests the case, so he files an answer, and now, of course, a trial is necessary, what is your experience of what's contained inside that answer?
Well, more often than not, Dennis, we know we're going to hear something about habitability. Every tenant, when pressed to answer a suit, is going to come up with some statement that will be included that says something wasn't repaired, or the landlord or the management company didn't take care of business the way they should.
And that is my experience, that every time I receive an answer, almost without exception, for a non-payment of rent case, there is a laundry list of items that the tenant claims is wrong with the premises, from leaking pipes to leaking roofs to torn screens to broken windows to no heat, appliances not working, and I get the same call from every client when I send them a copy of the answer, and they all say, probably just what you say is, he never told me that. This is a brand new unit, or there's nothing wrong with this unit, or I certainly haven't been informed. I'm a good landlord. And of course, I have to always talk my clients down to say, listen, this happens in every single case, that the tenants make up this stuff or potentially even vandalize their own units. They'll pull down the smoke detectors. So after a long time of doing this, and now being in my 42nd year, I came up with a new notice. That notice is on my website at evict123.com. It's a 3-day notice. And what this notice kind of changes the playing field. Because what we're doing now is we're putting on to the bottom of the 3-day notice a wonderful new paragraph. And that paragraph goes something like this. It states that we do not know of any issues with your apartment. And we take our job as a landlord very seriously. So please, if there's anything wrong with your apartment, please put it in writing to me. As soon as we get that, we will immediately inspect and correct if necessary. But of course, if we don't get a writing, then we'll assume that nothing is wrong with your unit. So we've been using this in court, and when the tenant starts with the laundry list of items, which of course my client has already stated that they never said anything to them, and in fact maybe they've even inspected the unit and those things aren't irreparably working, then in that situation you have the tenant on the stand and you're saying, well, you know, you're claiming all these things are wrong, but did you put anything in writing to the landlord when he asked you right on the notice? And of course the tenant will not be able to produce anything in writing. So on that basis, what you have is a tenant who's going to look like a liar on the stand. And we've been using this very successfully to defeat habitability claims. So for the landlords out there, if you've got a 3-day notice, throw it out and use the one that's on my website, again, evict123.com. And I think you'll have a much easier time if you're ever faced with a habitability problem in court.
That's a great idea, Dennis, and I can definitely see the value in that. So many times we'll go to court, and the judge might, at this point, know that there really is no habitability issue. But when you can explain it to them and say, hey, we gave them this paperwork, they failed to respond, let's move this forward, I think it gives you some more weight, for sure. I definitely see value in it.
And also, you know, we're dealing with a situation where specifically in the Los Angeles courts, we have the wonderful Governor Brown, who's appointed free attorneys for tenants in eviction cases, which again is just a waste of our money, but that's where our government thinks money should be spent, so that these tenants, of course, can delay their proceedings. And of course, these attorneys ask for jury trials. Well, when you're facing a complicated, long, and expensive jury trials, as they tend to be, it's really nice to have this ammunition in your 3-day notice where you can literally knock out the claim of habitability and basically let them sit there in the wind with really nothing to say. So I'm really recommending that the landlords out there use this notice to give us a little bit more power, because quite frankly, the playing field, the way the laws are not even.
Definitely not, I agree.
So here we are. We always like to expand on our questions and answers that appear in the Apartment Owners magazine. Oh, and by the way, on October 25th, I'll be speaking at 9 o'clock at the Los Angeles Convention Center. We're going to talk about the evils of the spread of rent control, talking about what we can do with regard to Proposition 10, and also what we can do, assuming we are under rent control, how can we somehow get out of the grips of rent control. But in any event, let's go to some questions that have appeared in the AOA magazine, and let's see how we can do with them.
Dennis, I reached back all the way to 2012. We have, often we'll have owners that come to us and they just don't have complete files. Maybe they inherited a property, or they're helping maybe a parent, and they won't really know what's going on in the unit. They won't know what the terms are. And you can say, well, we'll fill out an estoppel agreement, but I don't know that there's a law that forces a tenant to actually work through an estoppel agreement. I found this question of value. I recently bought a 4-unit apartment house at a foreclosure sale. One of the units is occupied by a person who refuses to identify himself or state if he is a tenant. This is a rent-controlled building. How do I handle this situation?
Okay, so we see this a lot where investors think they're getting a great deal at a foreclosure sale. Unfortunately, they're picking a place in rent control land, such as Los Angeles. And so you buy this place, you see what you're paying per door. It seems like a good idea. Of course, the previous owner is out of the picture and doesn't want to certainly help the new owner. And what we have here is a building, and you walk over, you introduce yourself under the law. You have to send a letter to your tenants when you buy a building stating your name, your address, and it has to be a physical address, your phone number, and times when payments, times when you can be contacted during the day. So that's kind of like an ownership letter. I guess you do that when you're taking over management, I would presume as well, correct?
Sure, we send a welcome letter out, yeah.
So you send this letter out, you knock on the door, and you walk up to the tenant, and the tenant might say to you, I don't know who you are, I'm not talking to you. So you say, okay, then let me come back with the deed. So you come back with the deed, and he goes, okay, yeah, I see the deed, I see your name on it, I'm not talking to you. Well, what do you mean you're not talking to me? Well, I don't want to talk to you. Okay, well then just tell me what your name is. I don't even know what your name is and what you pay for rent. And these people won't tell you. And what do? You can't just start an eviction where you're going to serve them with a 60-day notice to vacate, even though they're on a month-to-month tenancy, because you're under rent control. You have to have cause to evict. Well, he's not paying the rent. I'm going to serve him with a 3-day notice. But what's his name? And what's the rent? How do you even know? So these are very difficult situations where you're dealing with rent control, which is supposed to be a shield to protect tenants. But the truth is, they use rent control as a sword to kill landlords, and that's what they do. So when we have situations like this, we're debt collectors. We collect millions of dollars for our clients on the judgments that we get against their tenants. So we actually have services that will allow us for pretty much to know who's living in a particular unit. So if we have an address, we can look it up and we can actually get the names of the people who are there. These are people who apply for credit and put that as their address. So in a general term, we will be able to figure out what their names are. Once we have that, then what we'll do is we'll send that person a letter stating we assume that this is your name, and we assume that the rent is, and then fill in the blanks. You can just pick a rent that you think what it is, make it market value, and if we don't hear from you, we're going to then assume that that's correct. So we wait a little bit of time, and then we serve a 3-day notice to pay the rent in the name of John Smith, where the rent is $1,500, and of course nothing is paid. And in that situation, what we do is we then file a lawsuit. Now, I don't really care who this person is. Maybe we got the name wrong. Maybe the database was wrong. But unless he enters that lawsuit, what's going to happen is at the end of the lawsuit, I'm going to get a judgment against this John Smith, but I'm also going to get a judgment against all parties in possession, which means that unless he does something, he's getting evicted. Now, what does that mean? So in most situations, if they're dishonest, they might do nothing. Well, that's great. He's going to get evicted at the end. But otherwise, he's forced to jump into the lawsuit. He'll either jump in as to the name that we figured out what it was, and he'll file a response where he's going to give me a laundry list of things wrong. Or he'll jump in as what they call an ReEtta claimant, where he will state, hey, I have a possessory interest in this property. My name is, Paula Smith, and this is not what my correct rent is. Well, once they jump into the lawsuit, now we'll do discovery, which means we'll send them out questions. And by sending them out questions, we'll say, what is your rent? Show us any rent receipts that you have. And generally with that situation, we've kind of cornered them. So when we get to court, we'll see if we can settle with them, and if we can, where they get out. If not, maybe they'll be able to prove that the rent isn't $1,500. Maybe they'll prove that the rent is $1,400, which means that our 3-day notice is wrong, which means we can't win the case. But at least now we have the information and we can start the case over again the second time. So on these foreclosures, you get situations where you can't really determine who's there and they're not telling you.
Dennis, I've seen, I think you mentioned that ReEtta claim.
Yes.
Prejudgment claim to right of possession. I've seen attorneys include those at the onset, and then I've seen them included once they get a judgment. When is the smart time to serve that?
Okay, what they call a prejudgment claimant form, we serve that in every single case at the beginning of the case, which states that, hey, if there's any unknown occupants there, open your mouth now, because if I don't serve it now, what's going to happen is at the end of the case, when I have a judgment, and it's going to go to the sheriff's office, and the sheriff's office then posts a 5-day you better get out notice, any claimant can file paperwork and stop the eviction. They do it Marilyn Monroe, Chevy Chase, they make up these names. So you have to do it at the beginning. This is one of these what they call do-good laws, where it seems really good at the beginning to give somebody a chance, but just like the comfort pet, they all become bastardized. So back when I was a very, very young attorney, there was a husband and wife by the name of Mr. and Mrs. ReEtta. And what happened was that the lawsuit was brought only in the name of the husband for non-payment of rent. And this proceeded based on non-payment of rent. They got a judgment. Okay, maybe the landlord didn't want to include the wife. He just thought, well, the main tenant is the husband. So they filed a lawsuit saying, Mrs. ReEtta filed a lawsuit saying that, hey, I have possessory rents. Maybe I paid the landlord the money, and my husband didn't say. So I have the right to basically come into this lawsuit if I want to, and at least have my day in court, because otherwise I'm getting dispossessed from the property and never having a chance. Sounds like a reasonable idea, but the truth is, every single case once this lawsuit started, you'd have people making up names at the beginning, at the end of the case, claiming that they were positions, that they had a possessory interest in the premises and delaying the sheriff.
I saw that happen where the attorney actually had to file an entirely new eviction lawsuit, created a huge delay, and I think the tenant had a utility bill in their name. And they trashed their own credit by adding themselves to the lawsuit at the end of it, but they created a delay, and so I see the value in serving that at the onset.
And
Makes sense.
This state is so crazy, unbelievable. If you think about it, who in life wants to become a defendant? Who in life wants to be sued? I could see where you choose to sue somebody, but do you ever wake up one morning and say, you know, I really want to be sued, right? Well, this law allows people to jump into any lawsuits, which is what they do. However, by serving the paperwork at the beginning of the lawsuit, it doesn't create anything for them but harm. So that's why in our cases, we file that in every single. You do have to wait a little bit longer before you take a default. It's an extra 5 days. But it's certainly worth it because this would be played in every single case where they would delay the case at the end, and then we'd have to have another court appearance at the end.
Makes sense. Absolutely. Hey, shifting gears to commercial property management and commercial ownership. I have something going right now where the owner of some medical buildings in Alhambra is asking me, and I really don't know the answer to this question, if he can force his tenants who have put lettered stickers on their windows. It's a complex with 6 buildings, 2 medical towers, and then some restaurants and smaller offices behind. And the folks in the offices behind have put letters on their windows, and they've been there for 10 years. Now this owner just did a $1 million remodel, and his place is looking good. And he's coming to me saying, force those tenants to scrape their windows. I want it to look clean. And my staff, someone pointed out to me, you know, they've been there for 10 years. Any idea, Dennis, how something like this might play out in court?
Well, we see this also even in residential property where you have this beautiful apartment house facing the street, and then you've got people who are just, you know, putting up things in their windows or putting up lights or something outside, and it just doesn't have that uniformity look for the building. So the first thing we do is, actually we've had it where a tenant put in the window a sign that faced the street that said, "This landlord is a slum lord, don't rent from here." And what are you going to do? It's in a rent-controlled area. So the first thing you do is you look at the terms of the lease. And you see if, in fact, there's some language in the lease that would prevent that. So many times it's going to be contained in residential leases. And we're back. Took a little break there, and we're back to a question. Dave, go ahead.
Dennis, on Section 8, which I used to see was really in vogue years and years ago, not so much now, back when owners had trouble filling units, Section 8 was a great way to go. For more than a decade, it really hasn't worked for a lot of our owners. Is it easy to disassemble if you have a unit that's been Section 8 and you want to take it out of that program? Can you do that, or are you forced to continue?
Well, it depends. If you're in a non-rent controlled area, which unfortunately with Proposition 10, every place might be rent controlled. But if you're in a non-rent controlled area, it's a pretty simple thing. Assuming the tenant is on a month-to-month tenancy, we need to serve a 90-day notice to vacate. We do have to have a reason, but you can use economic reasons. So we have a plethora of reasons of why economically you want to get out of the auspices of Section 8. But unfortunately, if you're in a rent-controlled area, there's really no way to get out. As I say to my clients, once you sign up with Section 8 for a rent-controlled area, the tenant will stay there until your grandchildren have grandchildren. So for some landlords, some property management, Section 8 is a good business decision for them. That's their business model. I find, and a lot of my clients find, that the dealing with Section 8, the amount of extra paperwork, the inspections, you'll have a situation where a tenant will not allow an inspection, and therefore it won't pass inspection. So what's the harm? Oh, the harm is that the landlord isn't paid until the inspection can be made. And even though it's the tenant who's creating the problem by not allowing people in. So trying to get a rent increase, you know, in Los Angeles, we know that if you have a rent-controlled unit, you're entitled to a 3% rent increase every year. It's not much, but at least you can do that. If you have a Section 8 tenant that's in Los Angeles rent control, you can't get the 3%. The only way you can get more money is if it is approved by Section 8. So what can you do? Make a phone call. Make 10 phone calls. See how many times they call you back. Or write a letter. See how many times they answer it. So it becomes much more problematic. And I have asked, and I've spoken to countless groups, and I have asked them, when a normal tenant vacates a unit, and maybe you can tell me this, when a normal tenant vacates a unit versus a Section 8 tenant vacating a unit, do you find that there's much more property damage, more wear and tear for Section 8?
It's common knowledge, and I think most landlords will tell you, at least the landlords I work with, that your properties can get a bit beat up when they're in Section 8 programs, for sure. So
I would caution landlords not to get involved with Section 8. It's always best, and of course this is my political viewpoint, it's always best not to let the government get into your pocket. As soon as they do, then they're going to make demands. So it's better to just keep it a one-on-one relationship between you and your tenant. Obviously, make the repairs that you're supposed to make, but at least you'll be able to get your rent increases, and you'll have more power if you want to obviously have that tenant vacate the unit. Any other questions, young sir?
You started early on talking about service animals. Can you tell me, Dennis, has there ever been an instance when an owner or landlord came to you and had justifiable cause to ban an animal?
Well, first of all, most buildings and rental agreements have a no pet policy because it's just wear and tear on the property. Or landlords are afraid of lawsuits dealing with attacks by dogs. causes insurance to go up. So it's just a good idea to have a no pet policy for your buildings, even if you like dogs yourself. But because we're running a business here, and don't lose the sight of what we're trying to accomplish here. Now, for some, it might be a good business model to have an all-dog building. If that's your business model, then all power to you. But as a general rule, most landlords don't want to have pets. Well, here we go again with that do-good law, where under the Disabilities Act for both California and the federal government, you have to allow for a reasonable accommodation if somebody has a disability. For example, you're in a wheelchair. Well, you have to allow, at the tenant's cost, to put in a ramp or to put in handlebars in a shower. And I have no problem with that. But the issue is then, of course, if it's a service dog, like a seeing eye dog or a signal dog, that's a dog that will bark when someone's knocking on the door or come over and knock you. I can see that. But now, of course, they expanded it to comfort pets, where anybody on this planet can go to any doctor and get a letter from a medical professional, it doesn't have to be a doctor, but any, quote, medical professional, and on that basis they have the right to have a dog. And in fact, or a cat, or you name it, if in fact you state that you don't want to, then you haven't granted that reasonable accommodation. You're going to find yourself in a federal discrimination lawsuit. So what can you do to prevent these dogs? You have to go on the basis of what is a reasonable accommodation. So if you have a very aggressive dog that has bit somebody, but yet that dog has been classified as a comfort animal, in that situation, you can send that tenant a letter saying, I don't mind granting you a reasonable accommodation to have this dog, but this dog's got to go. You got to get yourself another dog because it's unreasonable, now that I've already known that this dog has propensity to bite, to continue to allow this dog to remain in my property. So these do-good laws, there's no way to check them. There's no way to contest their findings, and therefore they should be banned. I kid you not, and I wrote it up in the Apartment Owners magazine, that I had a client whose tenant got a pet and showed a letter from a doctor, full-on doctor, that this person needed the pet, and he wanted to know whether in fact he had to allow this pet there. Now the question is, what was the pet?
I'm waiting.
Are you waiting?
Let's hear it.
It was a rooster. I kid you not. This moronic doctor wrote a letter saying that this person had a disability, and that disability required for comfort to have a rooster. However, this property was located in the city of Corona, and with some quick research I realized that that's considered a barnyard animal, which is not permitted in residential places. So, notwithstanding the letter from the medical professional, we forced that tenant to get rid of the rooster. But you can just see the absurdity of this when you can state that anybody has a need for a comfort animal and can get any doctor to fill out a prescription for that.
Understood. Okay. Hey, my last question, and this is a hot topic these days with all the electric vehicles. Charging stations. Are owners going to be forced to pay for charging stations?
Good question. Under the California law, and I forget how many units, but I think it's 5 or more units, the owner has to allow a tenant to put in a charging station at his own cost. At his own cost.
Okay.
But then the next question is, well, who the hell pays for the electricity? Because obviously if they're going to wire this charging station in the garage, the tenant's meter's not close to there, so who's going to pay for it? And under California law, the tenant still has to pay for the electricity. And it works out, believe it or not, they've done studies, and the general cost, the average cost for the electricity is $2.50 per day. So if you're a landlord and a tenant gets one of these cars, and actually I'm kind of a fan of these electric cars. I think that might be my next car. I know my son got a Tesla and loves it. But if he does put it in, you have to allow him to put it in at his own cost. and then you are allowed to surcharge the rent with regard to charging for that electricity $2.50 per day.
Even on a rent control?
Even on a rent control, because it's an additional service that you're giving them.
I see, good.
Anyway, David, I appreciate you coming down. We got to do this again.
This was great.
Once again, David Crown is from Los Angeles Property Management Group. You can find him on the internet at losangelespropertymanagementgroup.com. I personally recommend them. They are a great organization. I have personal experience with them, and I'm sure you can call him and he'll answer any questions. What's your phone number?
818-646-8151. That's my direct line.
Is that it? One more time.
818-646-8151.
And if anybody needs to call me, I have a toll-free number. It's right over my shoulder here. It's 1-800-77-EVICT. Or you can check us out on the internet at evict123.com. I've got all my free forms there, podcast, which you'll be seeing this, and also instructional videos, legal issues. So there's a whole bunch of stuff there. Feel free to go there. And David,
Thanks,
nice having
Dennis.
you here.
Great to be here. Thank you.